You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 85. Picture this throughout the world, international design registration. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. Now, wouldn't it be wonderful if you could file a patent application in one place, get it examined by one examiner, and if you get a patent, you have worldwide patent protection, so a worldwide patent. Now, that would be wonderful, but that's just not how the patent system works. You have to have a separate patent for each country that you want patent protection in. Now, there are some regions that have regional patents, so it can cover more than one country, but for the most part, one patent is for one country. Now, there are some simplifying processes that you can do in order to cut out some of the steps, so you're not starting from scratch from each country, and I talked about that in several episodes when I talked about PCT applications. That stands for the Patent Cooperation Treaty. Now, you still have to have your patent examined in each country, but you essentially can have a single patent application that gets examined, one examiner initially at an international office, but then later on gets examined by examiners in each country. Now, I'm not going to go into all the PCT procedures because I already talked about them in earlier podcasts. But PCTs are only for utility applications. These are for inventions that have uses. They're not for new designs that you want patented. So you can't file a PCT design application. Fortunately, there's another type of application that's similar to a PCT application, and it's called an International Design Registration System, or IDR for short. You'll also hear it called the Hague Agreement or Hague Convention because it's an international agreement under the Hague Convention. So if you're interested in getting protection worldwide for things like the look of a 3D objects or 2D patterns or fonts or icons, then you might want to think about using the IDR. There are, I think, around 70 countries that are part of it now. So if you want to design protection using this procedure, you want to make sure that the countries you're interested in are part of this agreement, or you have to use some other process. The IDR is actually closer to a true worldwide patent than a PCT application, but it's still not 100% there. But there will generally be fewer interactions that you'll have with individual countries for design application, where you'll get it allowed, than you would with the utility PCT application, where there's still a substantial amount of interaction that you'll have with patent examiners in each country that you want protection in. Now, even though the IDR has been around for a long time, the U.S. only joined this treaty in 2015, so it's fairly new for people in the United States to be able to file a design application through this process. Let me go over briefly how you would protect designs if you don't use the IDR. What would happen is that if you filed your U.S. design application, you would have 6 months to file in countries A, B, C, D, or whatever country that you want to file in. Now, that 6 months is important in designs because in utility patents, you have 12 months to file in other countries or file a PCT application. For design patents, you usually only have 6 months if you want to claim priority to the earliest filed application. So what you do if you want to file an international design application is that you file a single international application. And what you could do is you could read the guide. The World Intellectual Property Organization, called WIPO, puts out for international designs. And the PDF, it's 128 pages, or you can have an attorney do it. It's your choice. I'm not telling you what to do, but you can decide how you want to spend your time, whether you want to spend it designing things or reading legal documents. Obviously, I can't sum up 128 pages in a 10-minute podcast, but what happens is that when you file your single application, you file it with one of many offices throughout the world. The U.S. has one. I'd recommend filing in the U.S. and not other countries, and there's also the International Bureau, but where you can file depends on your situation and where you're a resident, so you want to make sure you file in the right place, but I recommend if you can file in the U.S. that you do that. Now, when you file it, at the time of filing, you designate the countries you want protection for. Now, each country is going to have a fee that you pay upfront, and the countries are going to fall into one of 3 categories for examination. For some countries, they don't examine your design at all. It's just considered registered. If someone wants to cancel your design later because they don't think that you should have protection for it, that would happen at a later stage. But by default, there are countries where it's just considered registered, and that's called a level 1 country. Then there are level 2 countries, and these countries don't have much examination, but there's a little bit. But it's not to see if your design is new. They're just checking to see if your design is considered immoral, or you're trying to register their state flag, or something that's just not allowed to be registered in a certain category. And then there are level 3 countries, and these are the countries that will do a full examination, like an examine in the US, where they're going to see if your design is new and non-obvious. If you want to know how much it's going to cost in filing fees, you can go to the World Intellectual Property Organization fee calculator for international designs. You can click the type of design that you're doing. There are checkboxes for the countries that you want. There is a standard fee that you just have to pay to do the application, and then you pay per country or per region. Now, it might be as low as $70 for a country like Hungary right now, or it could be over $600 for Japan if you're a small entity, such as a small business. You can get a European Union registration in a single designation, so that covers, I believe, around 28 countries right now, and that's really helpful instead of trying to pick individual countries, but there are pros and cons to each of these approaches. Now, when you file it, WIPO will notify all the countries you designated that there's an international design that you filed. Now, just like in PCT applications, you can do a U.S. design application first and then do the Hague international filing within 6 months. And maybe you want to do that if you're not sure if you want international protection, or you can just file the international application to start with and just designate the U.S. As one of the countries that you want. And so what happens when you file it? A WIPO examiner is going to look for formalities. Do you have the right margins on your design? Are the lines clear? And stuff like that. There are lots of requirements for how drawings have to be done, and some of these are going to be different compared to the U.S. Design application requirements. One of which is that in an international application, you can have photographs. In the U.S. design, you're not. And there are differences in numbers and labeling, and all that stuff is in the guide. When you file it, you have to fill out some forms, such as called the request, some information about you as the applicant, certain number of copies that might be needed, what goods that these marks are going to, not these marks, what goods this design is going to be on, and of course all the fees for the drawings. After that, after it's approved, the design is going to be published by WIPO. Countries either have 6 months or 12 months to refuse. Now, here's why the whole system is not exactly like a worldwide design patent. If it gets allowed by some countries, great, there's nothing else you need to do. It's registered and you have protection in those countries. If it gets refused, then you have to deal with the design that got refused and the specific countries that have refused it. But let's take a simple case that it doesn't get refused. What you have protection for up to 15 years in most places to keep protection. But you have to pay a renewal fee at the 5-year and 10-year mark. In the US, you actually don't have to pay those renewal fees. But if you want protection to remain in force in other countries, you will have to pay those renewal fees. But maybe what can happen is that you file your industrial design application, you get allowed in many countries because they just register your design and they don't look at it at all. But in the US, it gets refused because your design is considered obvious according to the US obviousness rules. Maybe another country allows it, even though it also evaluated your design based on obviousness, but what counts as obvious in one country, the rule may be different than what counts as obvious in another country. So you'd have to have correspondence with all the countries that rejected your application to argue that you should get protection. The countries are not allowed to reject your application because the drawings aren't done according to their standards. Once your drawings are allowed by WIPO, then those are the allowed drawings. So the individual countries can't comment on the formalities, just on the allowability of protection of your designs according to the rules of their country. Now, it seems complicated, so why not just file in countries throughout the world individually? And the main reason is cost and convenience. If you have an international design, and go through the IDR, you pay one filing fee to one place, and instead of paying renewal fees for countries that require renewal fees for your design in 50 countries, you'll just pay one renewal fee to WIPO. In one estimate that I was looking at, it said that if you wanted to have a design in 6 level 2 countries, that might be about $45,000 altogether. But if you do an international design registration, it might be around $1,500. Now, that's real savings. Another advantage is that you can have up to 100 related designs in an international application, which is a lot more than the US allows. Another advantage with just having with just having one entity to make sure that your drawings are okay according to international rules is that if you did your drawings in the U.S. and regular U.S. application, the examiner might require you to have shading in your drawings that shows kind of the texture or curvature of surfaces. But in other countries, I believe like in South Korea, shading is not allowed. So if you start with the U.S. application and then try to go into other countries based on your U.S., you're going to have to start changing your drawings around for each country's rules. But you don't have to do that in an international design application. You just have to follow the international design rules. And once your drawings are allowed there, the individual countries can't tell you that you have to redo your drawings to their own rules, which can get pretty expensive. The main disadvantage of the IDR application is probably cost. If you're just interested in one or two countries, then it might not be worth it to do the IDR. There are also some other disadvantages that might apply in specific cases, but I can't cover each scenario in this episode. Now, as always, there are lots of details that I'm excluding, so check with your patent attorney to make sure everything is done right. There is something that I didn't go into called the European Community Design that can be filed either through an international design registration separately, or you can go directly into Europe. I didn't go into those, but that's really helpful if you want protection in Europe. And there are also pros and cons of filing your design in specific individual countries or getting a European registered community design. You can also file your logos as trademarks or through an international design or both. And that's a strategy you might want to look into to get more protection. If you want help with your patent applications, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamantpatentlaw.com. That's DIAMENT, patentlaw.com, or email me at adam@diamantpatentlaw.com, or call me at 424-281-0162. I'm Adam Diamant, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamant. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamant at patentingforinventors.com. That's patentingforinventors.com. Or call Diamant Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.